Hello. In this video, I will go over some ideas about search warrants, especially as they relate to digital evidence. I will be discussing ideas that you can also find in the reading entitled Probable Cause, Particularity, and Demonstrating a Nexus in the Digital World, written by Alicia Loy and Justin Fitzsimmons from the National White Collar Crime Center. So, let's get started. American citizens are protected from unlawful search and seizures. The search is the rummaging about a person's private property. This includes one's home, vehicle, personal devices, government records, and financial records. The seizure part of this is the taking of that person's property. This protection is encoded in the Fourth Amendment. To legally invade a citizen's privacy, law enforcement officers must submit an affidavit and apply for a warrant, which undergoes judicial review. When I refer to law enforcement officers, I mean agents at the local, state, and federal levels, such as your local Norfolk Police, as well as federal agencies like the FBI and ATF. Military police are also in these considerations, although as I understand it the process and some of the language is slightly different. An affidavit is a written statement made under oath by someone in law enforcement. We've all seen those crime shows where judges are woken up in the middle of the night to review and sign a warrant, followed by intense scenes of police barging past homeowners to gather evidence. Depending on the jurisdiction, it doesn't always have to be a judge. In Virginia, for instance, a magistrate can also authorize a search warrant. Before going further, I should mention that there are warrants authorizing law enforcement officers for all types of actions. An affidavit can be written for other activities such as arresting someone, doing a wiretap, extraditing someone, and more. But our focus here is search warrants. And the Fourth Amendment requires all warrants to present facts establishing three things. First, probable cause. Second, particularity in the place to be searched. Third, particularity in the persons or things to be seized. Okay, let's do the first. The warrant needs to show probable cause. Probable cause exists when a reasonable person, when presented with the facts, could believe there is a probability a crime occurred, the person named in the affidavit committed that crime, and a search of the location stated in the affidavit would reveal evidence of the crime. When establishing probable cause, the officer needs to explain the kind of evidence available. That evidence will be some type of audio, video, text, or image. It could be metadata. It could be the content of emails, pornography, DMs, video recordings. The officer also needs to identify one or more devices in the suspect's possession that may contain this evidence, and where this device is located. In other words, the audio, video, text, or images that are claimed to be evidence are stored on specific devices in specific locations. Maybe a thumb drive located in a home. Or a hard drive on someone's job. Or maybe it is the servers at a multinational company's Seattle location. It could even be DMs found on an Instagram account. When these facts are presented in an affidavit for a search warrant, and a person can reasonably conclude that a crime might have occurred, the person named could have committed that crime, and that the location to be searched might have evidence of that crime, the probable cause requirement has been met. Personally, I find that if I can see that probable cause is established, then the second and third search warrant requirements are usually already met. Now let's move to that second requirement. The second requirement is that the affidavit needs particularity in the place to be searched. To satisfy the particularity requirement, an officer must provide specific information. That information must describe a device's location and where evidence exists on the device. I gave some examples of this when discussing probable cause above. Here is another. If the evidence is believed to be on a personal server in someone's home, then the affidavit is written for the address of the person's residence and will likely state something like, quote, all files, databases, and database records on or in relation to those servers, end quote. Third, an affidavit must show particularity in the persons or things to be seized. Like the second requirement, establishing probable cause is a step in the direction of satisfying the third requirement. This third requirement requires an officer to describe, in detail, the evidence expected on the device. Here is an example of particularity in persons or things to be seized from the article by Loy and Fitzsimmons. They write, quote, "An officer searching for financial records cannot merely write financial records in the search warrant affidavit. They need to be as specific as possible to include information detailing the date range, type of records, and what evidence the records might reveal," end quote. While I am not a law enforcement officer, I imagine that even if this is a bit tedious, it is in the officer's best interest to invest time in writing a proper search warrant application. Suppose a warrant is not written properly, but somehow gets signed by a judge. Then imagine a person is arrested based on the evidence from the search and goes to trial. But then the defendant's lawyer gets the evidence thrown out because their client's Fourth Amendment rights had been violated. If that person was indeed guilty, then they will have committed a crime and go free, and their victims will not get justice. Let's end this video by discussing the nexus between digital evidence and cybercrimes. Loy and Fitzsimmons argue, quote, "The nexus answers the question, how is this evidence relevant to the current investigation," end quote. You may ask, isn't establishing a nexus the same as establishing probable cause? Not quite. Establishing probable cause is primarily about identifying the facts of the case, who, what, and where. Meanwhile, establishing a nexus is primarily about the how, and to a lesser degree the why. What happened? How was the crime commissioned? How did this person do it? Establishing this nexus can sometimes be a matter of looking at the document as a whole and generating these connections on your own. However, on many affidavits, there will be a section where the officer does some explaining. In that section, the nexus is established. This section may include the investigation leading up to the search warrant request. When this section is in search warrant applications, I find them to be interesting reading. You get an inside look into how crimes are investigated. Depending upon the complexity of the crime, this section can run to several pages. According to Lay and Fitzsimmons, quote, "An affidavit describing a seamless relationship between the defendant, the device, the evidence, the investigation, and potential crimes, creates a much higher burden for a defendant to challenge in court," end quote. In other words, establishing this nexus is important for a successful prosecution. Okay, that's it. Thank you for your time, and I hoped you learned a little more about search warrants.